This is new as well, so I'm assuming we're talking small and medium-sized businesses in here. All right. There is absolutely no doubt that health and safety legislation substantially prejudices against small business. Okay, there's no doubt about that at all. Every single company officer who has ever been prosecuted under health and safety legislation in Australia ever has been a small business owner, a working director with day-to-day involvement with the business. And in a couple of cases, literally the bloke holding the ladder. This legislation makes it easier to prosecute company officers than it was under the existing legislation. So that's you, and this is your company. In order to prosecute you as a company officer, I have to prosecute and commit the company of an offence. Then I have to prove that the same offence occurred with your consent, connivance, or neglect. Now, there have been 14 prosecutions under those provisions since 1984, 13 convictions and 1 acquittal, and the highest fine for an individual company officer was $45,000, which was 22% of the maximum. This is messy. Most small businesses, when they are faced with an occupational safety and health prosecution, go into liquidation. Okay? If your company has been liquidated or gone into administration, I can't prosecute it. And if I can't prosecute it, I can't convict it of an offence, and if I can't convict it of an offence, I can't have a crack at you. Which means the prosecutor has to apply to the WA Supreme Court to get your company reinstated for the purposes of prosecuting it and getting a fine which it can't pay because it's liquidated, just so I can have a crack at you. What this legislation does is says, I don't need to convict the company doesn't have to be convicted of an offence, consent, connivance and neglect doesn't apply. There's a new positive obligation of due diligence, which I'll show you in a moment. And if you don't meet your obligation of due diligence, there doesn't have to be an accident, doesn't have to be an incident, it's just if you have not met your obligations, I can prosecute you as an individual company officer. That's the single most significant change in my view in this legislation, apart from the penalties. It is administratively easier to prosecute company officers. One of the things to keep in mind, so we talk about and say, well, what should we do differently about this? The problem is the substantive duty hasn't really changed. There's been half a dozen prosecutions of company officers under this legislation in other jurisdictions. The substance of the duty is not any different. So every case that I have looked at of the prosecution of a company officer under WHS legislation, you would have got the same result if you prosecuted it under our existing occupational safety and health legislation. Okay? So this is the challenge. The challenge is not what do we do differently, the challenge is what we're doing at the moment appropriate? That's the real issue. And if you're comfortable with what you're doing, then, you know, this shouldn't make very much difference at all. But in my experience, very few organisations are actually properly managing their legal risk when it comes to this stuff. And a lot of what we do in the name of health and safety creates more legal risk than it manages. So we need to be a bit careful. This is what the positive obligations of due diligence require, but I would note it's not limited to these things, it includes these. Right? I don't think it'll be much broader than this, but we actually don't know the scope yet. And look, quite frankly, I don't think there's anything in here that is inconsistent with the way we currently talk about consent, connivance or neglect, and I don't think there's anything here that's not consistent with basic good management principles. So, you know, do you have actual up-to-date knowledge of WH work health and safety in your business? Do you know the operations of the business and the hazards and the risks? Are there resources available to manage them? The next one's probably important. I don't think organisations do this particularly well. Have you got good processes to get information about hazards and incidents and then properly consider them and respond to them? I think good hazard reporting and communication structures are really central to making this work well. Do you ensure the processes are implemented and so that you comply with the obligations, and then what do you do to check and make sure those things are in place and are working? So there's nothing in there that I think that jumps out as being really perverse or a real abomination. This is, reasonably good standard management practices, and not just around health and safety. I think the difficulty for most organisations and most managers in particular, it's just another thing that you have to do. And that's what makes it difficult.